This is filed as a termination of tenancy action. Mr. Thornton caused to be served on you a notice to quit on January the 2nd, asking you to move by February the 2nd. You didn't move, so I filed this action. There is no lease that I could see here. And at this point, Borgert Family Farms LLC wants this property back. Is that correct, Mr. Thornton?
That is correct, Your Honor.
Mr. Peck, what's your position?
I had a conversation with Keith Borgett last night. I farm for a living. I have a lot of equipment there. I had a good deal with Keith, and then the mother Doris passed away and everything changed, which I understand. But I talked with Keith last night. He told me to see that he thinks June 1st, I'll have everything out of there. And that's what Keith also thinks is there. And he's a Borgett. He's the guy who originally got the property through.
Well, he's not the owner of the property. The property belongs to Borgert Family Farms LLC. This happens a lot when the patriarch or matriarch passes, that's left to the kids, and then there are issues regarding that. They want you to move, not June, but now. What kind of stuff have you got there? Like major farming equipment?
Yes, I run my farming establishment out of there. So everything is there, and I have a place coming up April 21st. It's Oswald Farm. The father passed away, but they had to wait the 4 months. You know, he inherited it. So it's gonna be April 21st before we can do anything there. So, and I talked with Keith, and he said he's gonna talk to Cindy, the other Borgett. And he said he couldn't see why June 1st was a problem.
Well, they can certainly agree to that. There may not be agreement among the siblings as to what to do with this. The good news is we have to adjourn this matter at least 7 days. But this is more than just moving you and your bed and television out of there. You got lots of heavy duty farming equipment. So there are outbuildings, barns, that sort of thing.
Correct, Your Honor. And they're full. I mean, I've got 17 tractors there, 5 semis, my combine, my planters. I mean, everything for a farm is there. And I don't quite know where to move it to until April.
And you never had a lease?
No, me and Keith are good old country boys, and a handshake is what I go by, but I will never do that again. So
the unfortunate part, Your Honor, is Keith Borgett never had authority to rent the premises.
And he told me he did, and you know, I've been there 2 years and nobody's ever said a word until Doris passed away.
Did you pay rent?
Yes, $3,300 a month.
To Keith?
Yes.
Well, that's a pretty good deal for him. All right, well, this is complicated. As Avery Levine says, we're going to continue this to next Friday. Now, how is Borgert Family Farms LLC and Keith Borgert getting along?
Okay. The actual operating manager is Cindy Borgett of the LLC.
Okay. Well, perhaps they can work out some sort of agreement that he agrees to get his stuff out of there by a certain date, more than just 10 days from now. But today is the 20th of March. I'm going to continue this to next Friday, the 27th of March. That will be in the afternoon because we have pre-trials that morning. How about 1:45 next Friday, March 27th?
That works for me, Your Honor.
That works. I'll be back from Illinois Monday.
Now, in the ensuing week, it'd be very helpful if you and Mr. Thorne and all the Borgerts got on the same page. There could be some sort of agreement where they would issue a conditional order of dismissal. I'm just pulling this out of the air here, but let's just say you agree to move by June 1st. And if you move by June 1st, they could dismiss the case. The worst case scenario is you'd have 10 days from next Friday, March 27th, to move out, which would mean 17 tractors, 5 semis, all your equipment would have to be removed from there by April 6th.
Right.
Now, that's not a good solution, because if you don't move it, the sheriff's not gonna come out there and remove all that property. This is something that needs to be done by you. But as you indicated, you have no lease, you have a handshake agreement, and he's not the owner of the property. And $3,300 a month times 24 months is a lot of money. And I'm not sure what all that's about, but how many acres do you farm?
Close to 3,000.
Where? All over there in Colin Township?
All the way east of Colin, Farron Road. East is our farthest, clear north of Fulton, Michigan, to Vicksburg, to Centerville, kind of all around.
All right, well, you don't just pick that up like a suitcase.
No, I got to have a farm to go to, you know, and I'm trying to find one, and they're kind of hard to get nowadays. And
Yeah, that's certainly true. All right, well, Mr. Thornton does agricultural stuff. And he knows the territory, and perhaps some agreement can be worked out. But at this point, in order to start the process, they've served this notice to quit and had this hearing. So we'll revisit this next Friday. I said 1:45, and I'm not sure that's what I meant.
And when I get back, I can sit down with Cindy and Keith, and I think Cindy and Keith are no problem. It's Sue Roach that I'm being told is the biggest problem with all this.
Is Sue Roach a Borgert, or she's just a real estate agent?
She's a Borgert by, yeah, she was born a Borgert.
One thing we learn around here is everybody's related to everybody else, so at any rate, you guys have got some work to do between now and next Friday afternoon, and we'll see what our posture is at that time.
Did we stay with 1:45?
Yes, 1:45.
And I'll be there in person this time.
We had a special live appearance from Mr. Thornton because he had to be over here in Centerville anyway, so you guys are welcome to come live, or you can zoom in like this again next Friday afternoon.
I'll be there live because I'll be back.
All right, thank you.
All right, thank you, Your Honor.
Thanks.
Right. Oh, that is complicated, but we'll see how we do. Your defendants in a case, both of these are landlord is asking for possession. In the Hoops case, they're asking the rent to be paid, and in the Peck case, they're asking that the tenancy be terminated. In either case, you have a right to have an attorney to assist you in the matter. If you cannot afford an attorney, you can hire one. Excuse me, you can hire one, and if you cannot afford one, you could see if legal aid would represent you or other legal representations. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days and pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. If your landlord has asked you to be evicted because you haven't paid rent in a residential property, you may be eligible for some emergency financial assistance from the Michigan Department of Health and Human Services, Neighborhoods, Inc., Community Action Agency, or if you're a veteran, you may be eligible for some veterans benefits. You don't need a judgment against you to get financial assistance, the summons and complaint are sufficient and you have received those. Mr. Peck, that doesn't apply to you because your landlord's not asking you to pay the rent. They're just asking you to move. You may be able to reach an agreement with the landlord by going through mediation, also known as alternate dispute resolution. If both parties are interested in that, the court can help set it up. Or you may be able to work something out with the landlord, in which case they could file what's called a conditional order of dismissal. Let's start with Mr. Rognus's case, which is entitled Jose Lopez Garcia versus Stephanie Hoops and Raylan Hoops. The name Raylan is a lot more popular now, maybe, than when you were born. I think there'll be a lot of kids now named Raylan. Anyway, Mr. Rognus, the arrearage is substantial. At the time of filing, it was $4,200. What is it now?
At this point in time, Your Honor, it's the sum of $5,100. Insofar as costs, there's a $55 filing fee. Personal service on both the hoops total $121.60, and the statutory attorney fee of $75. The cost would total up to $251.60.
So the total is $5,351.60 through March.
Correct.
Ms. Hoops, could you unmute your microphone? All right, this rent is substantially behind. It's $900 a month. Hasn't been paid apparently since last October.
Your Honor,
Yes?
Mr. Lopez has been charging us $1,400 a month. He was going to throw us out if we did not pay that. So we've been paying $1,400 a month all year this last year. So I have to disagree with the amount that they say we owe. I think Mr. Lopez owes us some money.
So you're saying you've been paying $1,400 a month through 2026?
Yes, sir. From November of 2024. So from November 2024 to December, I believe, when the last month's rent was paid, we've paid him $1,400 a month. I didn't want to be
Because of
homeless.
a previous arrearage?
No, because he was going to throw us out. Our air conditioner broke, and he was reluctant to fix it. And he said the rent's going up, and if I had a problem with it, there's the door. And I wasn't going to put my kids on the street.
All right, so from November of 24 through December of 25, you paid $1,400 a month?
Yes, sir.
How did you pay it? By check?
Sometimes it was money order. Sometimes it was cash.
Did you get a receipt when you paid cash?
Yes, sir. I'm not entirely sure where all the receipts are. Every time I paid him, though, I got a receipt. He has a receipt book. Whether he has one or two receipt books, I don't know.
All right, then
But
you indicated you stopped paying rent now in December.
I believe it was December.
Well, he says it's November, but why
So
did
it
you
was
stop paying
November,
rent?
December, January, February. Miss Hoops was the main breadwinner. I was part-time delivery driver, stay-at-home dad, and she was planning on moving, and she had stopped paying rent so she could move.
Miss Hoops, do you no longer live at this address on
Correct.
Pamela Drive?
Correct.
So you moved out as of when?
January.
I have moved out too.
All right. That makes things easier.
I just haven't had a chance to turn the keys in to Mr. Lopez yet.
All right, do you have all your stuff out of there?
Yes, sir. There's a few things that I couldn't take with me, but it's boxed up stuff.
All right, let's see here. Andrew, I'm gonna use your numbers. I don't know if you sent me a judgment.
I believe that we did, Your Honor, send it over there on the 11th.
You usually do.
I can fax one over if you need me to.
Now, I'm gonna give you a figure to pay, but you don't have to pay it unless you wish to stay there. So if you've already vacated, do you have any objection to us picking a date like Monday? You'll be out by Monday and turning the keys.
For the hoopses?
Mr. Hoops.
Yes, I've already moved out, Your Honor.
All right. So you just need to turn in the
I
keys.
I could take the keys up to Mr. Lopez's work after I get out of work today.
All right. Now let me repeat this. I'm not ordering that you pay any money. I'm
Okay.
ordering that you pay money if you wish to stay there.
Understood.
Andy, I have a judgment in the electronic file. Elaine, could you print the judgment in Garcia versus Hoops? I don't seem to have it.
Freezing though across southern Michigan with the clouds still around. Show you things you get. This messaging.
Say that again.
I'm scared for the lawmakers who are in charge of actually getting the job done. What about this line of messaging?
Hey, sir, who just came in by telephone? Somebody's here by phone. Is that Mr. Hoops? Did I lose you?
No,
No, sir, I'm here.
Oh, well, who's 8012 who's talking in the middle of the court proceeding? I don't know who that is, but they're gone. Elaine, could you print the judgment that Andy sent? I don't seem to have a copy with the paper file. All right. Ms. Hoops, do you have any objection to the landlord taking immediate possession of these premises?
No, sir.
Mr. Hoops, do you?
No, sir.
All right, now I'm going to use these numbers and let me repeat what I said. This is through March. Rent is $5,100. $251.60 in costs for a total of $5,351.60. That's how much you have to pay if you wish to stay there. The plaintiff did not file a complaint for money damages. So if they're going to sue you for money under oath. So right now, I'm not ordering that you pay any money. I'm simply ordering that you vacate. And I will put in here, defendant has no objection to plaintiff taking possession.
All right. That works.
Mr. Hoops, when you turn in the keys, you can turn those into Adolfo Lopez. He's gonna be at Maria's Restaurant here in Sturgis on US 12.
Maria's, okay.
Yeah, rather than to Esperanza.
Okay.
And they're gonna need a forwarding address from you too.
Alrighty.
All right, I put defendants have no objection to plaintiff taking possession. They'll turn in the keys. So we're not going to fight about money. We may not fight about it at all unless the plaintiff files either a small claims or general civil claim for money damages, in which case we'll address money. This is only about possession. So you turn in the keys by the end of the day, he will take possession of the premises and you all can go on about your business unless he files a claim for money damages. All right, so Ms. Hoops, you have any questions?
No, sir.
Mr. Hoops?
No, sir.
All right, along with that keys, you need to give your forwarding address in writing. So you need to do that as well. All right, thank you both for being here.
Yes, sir.
Yes.
Thank you for your time.
Thank you.
All right,
Thank you, Your
okay,
Honor.
you're good to go. Ambassadors for Christ versus Null and Void. James Null, 26377 LT. He is not present, but Carrie Bartholomew is present. And Miss Whitney, which case are you here on?
Hang on, I gotta look at the paper here.
He's on the case I'm on, Your Honor. It's the portfolio recovery.
Mr. Work's case.
Whitney matter. It's just her motion for installment payments.
All right, yes, I have Kathy Beach.
And the beach matter is on mine, Your Honor.
And Mr. Nate is here on Kathy Beach. She is not present.
That one will be quick. I don't know if she's planning on appearing or if counsel is, but we do have a consent
Well,
judgment.
let me call it. Let me call it.
Yeah.
This is LVNV funding versus Kathy Beach, 252464 GC. This plaintiff's motion for summary disposition. This matter was set for 10 o'clock. It's now 10:12. Kathy Beach is not present. Mr. Preston Nate is here for the plaintiff. They do have counsel, Sonny Miller of Farmington, Michigan, Robert Gitmead and Associates. Mr. Nate, what do you know?
So we did get this one resolved, so we will not need to move forward with the motion today. We do have a signed consent judgment. It sounds like it probably didn't make its way to your bench yet, so I can make sure we resend that or make sure the court gets a copy of that, but this one's all resolved.
All right, very good. We're moving. We're vacating everything in this building, 50 years worth of stuff out so they can do construction. So the staff has been preoccupied. We've been actually closed for a couple days. So we'll find that. If we don't have it, we will look for consent judgment or request it.
Yeah, that'll be fine.
All right. Thank you for checking in to let us know what the status was.
You bet. Thank you, Your Honor. Appreciate it.
All right. All right, Laura, I left the Janice Whitney case in my office, I think. Because I can't find it. But in the meantime, we're gonna do Ambassadors for Christ versus null and void. File number is 26377 LT. This is filed as a termination of tenancy. Defendants were personally served. Defendant was Mr. Null. Mr. Dutka, what's the status here?
Last I checked with my client, I believe he still occupies the premises, so he not being present, we'd ask for judgment to be entered.
Ms. McNary, is he still there?
Yes, he is. Can you hear me?
Yes, I can hear you and see you. We're good now.
All right.
All right. Well, he was personally served. It is a termination of tenancy. He had the keys.
I had Megan in my office and hadn't had a chance to speak to Misty yet, so she sent her down to district court. Now I don't know where the young lady is.
Who?
John Beachy's
Daughter.
daughter, I'm unsure of her name.
Well, she supposedly has the keys. Elaine or Michelle, did she show up there with the keys? I found it. Thank you.
Okay, I have.
All right, very good. All right, you're good to go. Thank you. All right, I got a lot of plates spinning here. Mr. Dutka, let's see if I have a judgment in here.
Hopefully, Your Honor, I did leave one off yesterday, but I realize, yeah, the court is in flux, so to speak.
I think Elaine gave me several judgments. All right, we'll do a default. Defendant has until March 30th. To vacate and appeal. I believe I have a copy of that judgment. Elaine had it for me.
I had some here and they were with the other paperwork. And no one dropped off the key yet, so.
I think they got it squared away.
Oh, okay.
Laura, did you need our office's assistance?
I think we've accomplished it.
Okay.
We were trying to get the keys for the storage unit from Mr. Beachy to Ms. Sudbury.
Okay.
And Kendra was willing to assist with that, and we have done that.
Okay, perfect. Thank you. I just wanted to check.
Well, I appreciate their help. She was on top of it and they were here. So I think the next step is she's gonna get her stuff out of the storage unit. We're not done fighting about it yet, but we have a hearing set for next Friday.
All right, thank you.
All right. So no, he has until 3/30/26. Oops, that's a default. All right, Miss Bartholomew, you stay with me for a minute. We're going to switch gears for just a second. Mr. Dutka did have the judgment.
Very good. Thank you, Your Honor.
Thank you. All right, Ms. Bartholomew, we're going to come back to you in just a minute. In the meantime, however, we're going to skip to a general civil case, which is entitled Portfolio Recovery Associates versus Janice Whitney. The file number is 251216 GC. On behalf of Portfolio Recovery Associates is attorney Jeffrey Werber. This is a claim that was entered with a judgment in the amount of damages of $4,773.13. Defendant filed a request for installment payments of $75 per month. And that's a large debt for $75 per month. So what happens is you file the motion for installment payments, plaintiff objects to the amount, end up chasing our tails. So I just set everything for a hearing to get everybody in the same place at the same time. Mr. Werber has a lot of experience in this area and represents his clients well. All right, so here's where we are. The amount due according to the order is $4,915.13. It may have changed. $75 a month. It's taken about 6 or 7 years to pay that off at that rate. Mr. Werber, what could the plaintiff accept in this case?
You know, Your Honor, I did look at the defendant provided a lot of information here. She gave all her bills. She gave her budget. To me, after looking at all this, it seems like 75 is going to be a stretch for her. Am I correct, Miss Whitney?
Yes, sir.
Yeah. So, you know, I know it's going to take 6 years, but I don't know if she can afford to pay anymore looking at everything. So,
all right, well, if it's acceptable to you, it's certainly acceptable to me.
it seems like that's the route we're going to have to take because I don't think she can pay anymore looking at everything she provided. Now, I will say, if any funds have been, I don't know if any funds have been garnished from your paycheck. If they have, I'd ask that those go towards the balance. And Miss Whitney, I would tell you to take the order that I assume the judge is going to enter today to your place of employment as soon as possible to get the garn stopped.
Okay. Yeah, I have not. It hasn't been garnished yet, but I get paid Tuesday. So I'm assuming it will have caught up by then.
Yeah.
All right, I'm going to do this $75 every month starting April 1st. Do you have instructions on how to make the payment?
Yeah, Miss Whitney, you can mail us a check or money order. You can call us and make a payment over the phone, or you can go on our website, weberolsees.com, and make your payment there.
Okay, is it from that paperwork you sent that said you were going to garnish my wages?
Yes, that address and everything is on the paperwork.
Yep. Yep. But just make sure you pay by the 1st of each month.
I will do the best I can. I have what I have, and I don't have.
And I tell everybody, if you can't send 75, send 50 or send something just to know that because otherwise they'll move to set the thing aside and garnish your wages, which will not be very good.
No,
so I will do this order
now.
Effective today.
Do I pick up this paper from you, or because I could take it into work tonight?
Well, if you come over to the courthouse, or I'll tell you what, you call the court here in a little bit, and they can email a copy of this to you so you can take it into work.
Okay.
All right. Let me give you the number to call. 467.
Wait, pen. Okay, 467.
5623.
Oh, that's Michelle, I think, right?
Yes, that's Michelle.
Okay.
All right, Mr. Werber, thank you for your appearing and for your grace to the defendants.
I
$75.
appreciate that. Thank you, sir.
Yep, I wish you the
All
best
right.
of luck, Miss Whitney, and Judge, have a good weekend.
If I had it, I would
All
pay
right.
it.
Yep, take care.
That was set for 10. It's now 10:24. It could be worse. Let's go back to our landlord-tenant docket. And that matter was set for 9:50. So we're about 35 minutes behind, but our last Ambassador for Christ case is Ambassador for Christ Church versus Carrie Bartholomew. Carrie Bartholomew is here with us. Miss Bartholomew, you are a tenant in a landlord-tenant proceeding. Your landlord has asked you to terminate your tenancy and have you vacate this room you have at this property on South Main Street. As such, you have certain rights. You have the right to hire a lawyer. If you can't afford an attorney, the county could appoint one for you at excuse me, that's a criminal case. If you cannot afford an attorney, you can see if legal aid would represent you or seek other legal representation. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first court appearance or file the written demand within 5 days and be prepared to pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. I'm doing a little house cleaning here. If you can reach an agreement with the landlord for some sort of agreed upon move out date, they could file something called a conditional order of dismissal. And Mr. Duck could prepare that. Or if both parties are interested, I could refer the matter to mediation for an attempted mediate settlement. That's never happened, but it might one day. All right. Miss Bartholomew, are you still there?
Yes, I'm still here.
Have you made any plan to try to move or?
I have actually started moving. I'm almost completely moved presently.
Well, I'm going to adjourn this matter, continue it to March 30th. What time did I set Mr. Dutt's other case for?
2:30, Your Honor.
We'll set it for 2:35.
And I have contacted legal aid. I've been assigned a lawyer on this case.
All right. If you move, you turn in your keys and give your forwarding address in writing within 4 days of your moving. If you don't move, we'll address this further on March 30th at 2:35. And if legal aid is going to come in and represent you, so be it. This is a month-to-month tenancy. It looks like they were trying to get a lot of people out of this place. I think there's 6 rooms in this building. I don't know all the details of what's going on. If you just move and turn in the keys, they could perhaps even dismiss the case, which wouldn't show as evicted on your record. So you stay in contact with Ms. McNary. If you move, turn in your keys. If you don't, we'll have a hearing on March 30th at 2:35.
Yep, I will be moved.
All right, thank you for your patience. You are here for landlord-tenant matters, and as such, you have certain rights. Your landlord has asked you to pay the rent or move, and as such, you have a right to hire a lawyer. If you cannot afford an attorney, you could see if legal aid would be available to represent you. You could seek other legal representation. You have a right to have the case heard here in St. Joseph County, where the property is located. You have the right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days and pay the $50 jury demand fee unless you're unable to pay it, and the court waives it for your inability to pay. Your landlord has asked you to be evicted from your residential property because you have not paid rent. You may be able to get assistance from the Michigan Department of Health and Human Services, Community Action Agency, Neighborhoods, Inc., or if you're a veteran, perhaps you may be eligible for some veterans housing assistance. We sent that information to you with the original packet of the summons. You do not need a judgment against you to receive assistance from the places listed above. Copy of the summons and complaint from your case are sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, we can schedule the matter for alternative community dispute resolution. You may be able to reach an agreement with the landlord that means the case would get dismissed upon some mutual agreement, in which case Mr. Weiner would prepare what's called a conditional order of dismissal. Also joining us is manager Chris Corpening from Memory Lane. Let me make a note here. Mr. Wynn, your landlord says that your rent is behind. Your rent is $875 per month. The time of filing, it was almost $37.50. Mr. Weiner, what's the current arrearage here today?
So the current arrearage, and I'll break it down. The current arrearage is $4,872.25. That will be the judgment amount. This is how we arrived at it. As of the date of filing, Your Honor, he owed $3,750 for February home and lot. And then also there were fees, which brought it to the total of $4,625. He also owed March, which added $925 in
so that's $875 in rent and $50 in late fee.
That's correct.
All right, so you're not breaking it down very well. Let me see if I can figure this. $3,500 in rent plus $875.
That's right.
Gives us $43.75. Plus we have another late fee, so that's $300 in late. So that's $4,675.
It's actually $4,625. It was actually $4,625.
Well, if we had $3,500.
I know he owed late fees going back to October.
$875.
Right.
That gives us $43.75.
Chris, can you help us on that?
Your Honor, when we first filed this, he owed October, November, December, January for $3,700, which was $875 a month plus the $50 late fee each month.
Yes.
And then sorry.
Okay. There must be a matter of a late fee. So how much are late fees?
$50.
We can't do this every time. It takes so long to do each case without having a clear indication of what is owed. So help me out. October through February, now March.
Yes.
At $875.
Plus a $50 late fee.
Yes, so we'll do the late fee separately.
Okay.
6 times 875 equals excuse me, yeah, 875 times 6 is 5,250. October, November, December, January, February, March, that's 6 months. Through March, the rent is $57.50 plus $300 in late fees, which is $55.50.
Yes.
Okay. And then we have court costs of $130.
You have
Filing fee of $52.10.
now the process server in this case, Your Honor, is $117.25. Filing fee of $130 and the attorney fees of $75. So the total costs are $322.25.
All right, let me stop you. I show our filing fee at $52.10.
Gonna go and look. Normally the filing fee is $130. $52.10. Nope, you got that correct, Your Honor. I apologize.
Okay. All right. 130 plus 52.10. Plus 75 is 257.10. If we add 257.10 to 5,500, we get 5,757.10. All right, Mr. Nguyen.
Yes.
They claim you haven't paid your rent in 6 months, October, November, December, January, February, and March. For each one of those months, there's a late fee, and that's $300. So your total rent and late fees through March is $5,550. What do you say to that?
Your Honor, I'm sorry to interrupt, but Mr. Nguyen did pay, Chris indicated, $1,000 on Friday, March 20th.
Right.
So we're going to give him credit for that. So
all right, so the total is now 4,550 plus 257.10 is 4,757.10.
Correct.
All right, Mr. Nguyen, apparently you paid $1,000 last Friday, which reduces the amount. Are you going to try to get caught up on your rent?
Yeah, the rent is right now I want to rent. Right now I want to pay every week for the $400 every week. But but I don't know how long and I pay off for this, and I'm going to rent.
Are you employed?
Right now, yes, sir. I started working the last
No,
Friday.
I'm not talking to you, sir. Your case, we haven't got to your case yet.
Okay,
this is
sorry,
Mr.
sir.
Nguyen.
I know.
Mr. Nguyen, are you employed?
Yes.
Where do you work?
I work at iBus.
At where?
iBus.
He works at
Iceberg?
Yes.
iBus, yeah.
Does anybody else live there or just you?
Only me.
How did you get so far behind?
Because I lost the money for somewhere else, but because I am behind.
Did you lose your job for a while?
No, as I lose the money, something is still in my money for, the car, is somebody steal my.
All right, well, you're gonna have to pay this or move. Maybe you can work something out. The law requires that we adjourn this matter 7 days. We will still be at the March.
Yeah, but I
That's
want to
next.
stay over. I want to stay over there, but I want to pay for rent. It's a wait for that, but I want
Do
to
you
pay.
have a tax refund coming?
Yeah, I have a tax coming already, but have not too much, only about 500, 600 something that a week because you have a tax, not too much mine. I have to tax a lot of money for the tax.
All right.
Only $6 I'll take back the tax coming back. That's it.
All right, well, let's set this. We've got several memory lanes cases for next week for 120. For March 30th.
And Chris,
Are you
perhaps,
missing work right now?
Yeah, I'm work right now. I work
All
every.
right, well, we're gonna do that. You can come by Zoom, but you can also come in live. We will still be in the month of March when I see you next week, so these numbers shouldn't change unless you pay money, then they will go down. But we're gonna do this again next week at 1:20, same time as today, next Monday, the 30th of March. I want you to see how much you can pay in the meantime, and you can go meet with your manager, Miss Corpening, and talk about your plan to repay this.
Yeah, but she told me and asked for me every week to pay $500 a week. He said it's okay, but I got care for that.
Well, if you can work something like that out, we could do what's called the conditional order of dismissal. All right, now we're going to do this again next Monday at 1:20. In the meantime, you need to go over and talk to the manager and see if you guys can come to some sort of agreement on how you're going to repay this. Okay, do you have any questions?
Nah, it's okay. I talked to manager for
All right, I will see you next Monday at 1:20.
Yeah, thank you. Thank you.
All right, good luck, sir.
Yeah, thank you so much.
All right, next is Emery Lane Mobile Home Park versus Rebecca Randall. No, 125 is Adams and Reynolds, and they're not here. So let's do Rebecca Randall because she is here and she's been advised of her rights. Miss Randall, this is file 26316 LT. Let me make a note. Your rent is a little more. It's $975 per month. At the time of filing, it was $1475 plus late fees. Mr. Weiner, what's the status here?
well, so we have a little issue that I want to advise you of. The status is she did catch up, but she still now she owes March rent of $975 of rent and $50 in late fees. And when she started, she had paid a down payment in installments and currently owes $425 of that down payment. So the total amount due is $1,450. The issue and she would like to work things out, but part of the problem is we just received on Friday, I was advised that she has now filed a complaint with the Department of Civil Rights, which we are defending. And I would not want any type of resolution to interfere with that action. So I don't want her using this this deficiency and the amount due to perceived in a negative way versus, you know, our defense of her.
So is this a rental to own? It's a rental purchase. It's $560 per month in lot rent and a purchase agreement of $415 per month.
Yes, that is correct, Your Honor.
Okay. Ms. Randall, what's your position? They contend that essentially you owe March's rent.
I do, Your Honor, I do owe March's rent. I've tried to have DHS help me. I've paid the $15.75 that I owed for February to catch up, plus the late fee. I am trying to do my best. I already talked to the people that I put the complaint in with and told them that I didn't want to proceed no further, that I'd like to work it out with Chris because of between her and I, we can come to some solution with this situation because the complaint was over my dog because my dog is a certified service dog and she has to be tied up to leash. And I got medical issues. So if I have to fall, she has to be able to get to somebody. And being on a chain, she cannot. That's what the complaint's about. And I already talked to the people and they're willing to drop it.
All right, well, that's a separate issue. There's a certified service dog, and there's a dog that people claim is a service dog.
No, mine is a mobility and a seizure dog.
Okay.
I have fibromyalgia and MS, and I also have seizures. That's what she's for.
Okay.
Your
So
Honor.
right now,
And
let's set that aside.
I'd like to work with Chris to pay off the owed rent and the fees or whatnot for this court case and move forward and continue to live here because I have no complaints here besides the service dog thing, and it's not a big deal.
All right. Well, let's continue this matter to
In a court, Your Honor, according to paperwork that they submitted with me, the last payment that was due for any deposit or anything was for February 2/1 of 26. It says $14.75, and then it was $9.75 after that every month, not including the late fee.
we're going to continue this to March 30th. 2026 at 1:30. You and Chris can work in the meantime and see if you can work something out.
Okay, Your Honor.
You're really only about 1 month behind.
Yes,
that
sir.
last guy was 6 months behind. It gets hard to get caught up. All right, Miss Randall, do you have any questions?
No, sir.
All right, you did a good job of logging in on time with your name. I could hear you and see you. You could give lessons to a lot of people we deal with. So you come in again next Monday at 1:30 and we'll see where we are at that time.
I will, Your Honor. Thank you, sir.
All right, thank you. Now, let's address our next case. I requested Pablo Bale to come as an interpreter. The title of the case is Memory Lane Mobile Home Park versus El Patron Mauricio.
It's me, Your Honor.
And are you Mauricio?
Yes, I am.
I thought there might be other people here as well, tenants. So stick with me for a minute. I get Mauricio, what's your last name?
Herrera.
Could you spell that for me?
Yes, it's ERREA. RA, no? RA, yeah.
All right, and what's your connection to El Patron?
I was working there, you know. I was the manager of this restaurant.
All right,
And
so
this
that
is
was in
the
Sturgis?
yes. This is the relation about the
And El
patron with me.
Patron rented this trailer for you as their manager?
They rent for the like 5, 6 waiter when we start to operation in Sturgis, like 1.5 years ago. And then
All right, that's, I thought there may be other people here. Are there other tenants in this trailer?
I don't understand that, Your Honor. Sorry.
Are there other people living in this trailer, unit
Right now,
226?
okay. Right now, no anymore. The manager of the trailers tell me I can have a lot of people without registration, and they have some kind of dog too. And she tell me a lot of things about it, like 1 month ago, and I start to figure it out that things. Right now, the house is empty. I be only me right now. There's nobody there because the people there is I try to some roommate for trying to pay half and a half, but because in the end they don't do the right things, and pues I start to tell them they can stay anymore because I'm going to have some issues. Like right now, they understand they can keep the dog, they can keep the stranger anymore, and that's happened like 1 week ago. And right now the house is just with me. I am only me there.
Pablo, I'd asked you to be here because I thought some of those tenants were gonna be here who were in the premise, and I didn't believe they spoke English. Maybe you could stick with us for a minute if we need some assistance.
Yes.
So
Okay.
there's nobody in the trailer right now, is that correct?
Nobody else, just me.
All right, so you're in the trailer. All right.
Yes, sir.
How much is rent due?
If I be
Oh, just a
right,
minute. I'm asking Mr. Weiner.
Okay, so the total amount as of February had been $2,175. And that included an October balance of $475, and then monthly fees for lot and home for November, December, January, and February. And then, so the total of all of that rent was $2,000.
All right, well, give me the rent through March. We're now into March.
So now the rent through March, and you correct me if I'm wrong, Chris, but I have down $3,450.
That is correct. That includes your late fees as well.
That includes the
All
late.
right, well, let's break the late fees out of that. This is very time consuming. So, how much is rent, Chris?
Rent is $975 a month.
I know, but how much is due through March?
That's January, February, March, 3 months, which is $975 times 3, $29.25, and he still has a balance for December of $255. All total $31.80.
Through March.
Excuse me, Your Honor, just 1 second. 1, 2, 3, and 2, 2, 5.
I had 3250.
Without fees, without late fees and pet fees, I have $3,180.
Right. Let's add in the late and pet fees. What do we have for those?
Pet fees are $75 for pet fees. That's 3 months. And $150 for late fees.
So pet fees are $225 and late fees are $150. All right, $31.80. I long for the days of the John Bush accounting sheets or the Christine Yancey form. It would take 3 seconds instead of 7 minutes.
I still have those, Your
31.80.
Honor.
What?
I still use those. I can pass them on to Stuart if you'd like.
Well, that would be very helpful.
Yeah, it might help,
Yeah.
Chris. If
Okay.
it helps the judge, it helps
Mhm.
everyone.
Okay.
All right, so then we have 3,555. All right, so then what do we have for court costs, Chris?
Have 322.25 for court costs, filing, and attorney fees. 322.25.
No, that's not correct. We have 130 filing fee, 52.50 service fee. Oh, maybe it is. There's a second fee of 65.15 and a 75. So that might be right. 130 plus
117.
52.10 plus 65.17 plus 75 is 322.27. Literally, this is taking way longer than it should. So we add 35.55 to that. We get 3,877.27 through March. Mr. Herrera, did you follow all that?
Yes, sir.
All right, so you understood all that?
Yeah.
All right, Pablo, you can bill us for this, but apparently we didn't have anybody that needed the service. I wanted to make sure he understood everything. His English is as good as mine. So the other tenants have vacated and we don't need your service. So thank you for coming in on short notice.
Thank you, Your Honor. All right.
All right, so Mr. Mauricio, do you plan to stay there?
It's my plan if I have the valuable opportunity for be there. Yes, Your Honor. I want to be there.
All
Stay
right,
there.
well, the law requires that we adjourn this matter for 1 week. So I'm going to continue this to next Monday, 3/30/26 at 1:40 p.m. Again, you should meet with Ms. Corpening and tell us what your plan is to try to get caught up on this rent.
Okay, I have some kind of plan right now. I try to have some option because, like I tell you, Your Honor, the house is already empty and clean, and just I come to the court to try to stay there. But if they don't want to, and if they want, I need to move the house. This is valuable too.
Yes, then you would need to move 10 days after that, which would be April 10th.
Okay.
All right. Do you have any questions? We're going to address this next Monday at 1:40.
1:40, sir. Thank you, Your Honor.
All right, very good.
Next
Thank
Monday.
you.
Thank you.
We have one more memory lane case that the parties apparently are not here. Memory lane versus Heather Adams and Wayne Reynolds. What do we know about this one?
Sorry, Your Honor. You say have one question. I can
yes
cut it out the call. is done with me?
Yes, you're good to go.
Okay, thank you.
All right, I'll remove you. All right, so this is file 263141, 314. The defendants are not here. They were personally served. What do you know about this one?
This one has a history, Your Honor. That's why the amount of money is so large. Mr. Bush had started this. He had 2 cases with them. They ended up owing a bit of money. By August 5th of 25, he obtained a judgment of $9,431. Then apparently either Adams or Reynolds signed paperwork for hardship, and he was allegedly getting $15,000 from a loan for a 401k. He never paid memory lanes. In that time period, they lost a son. And as a result of the loss of the child, Chris and the property owner worked with them, and they didn't execute on that judgment within the 90 days. So we started all over again after apparently the money must have been paid, but none of that $15,000 was paid to memory lanes. So now they owe us $15,000, $15,986 plus court costs, and I can break everything down for you if you would like.
Yes, I would.
All right. So by February 10th of 2026, the amount due was $13,905 in rent. The amount of late fees and prior costs totaled $981, which gave us a total of $14,886. March rent has now become due. That's $1,050. March late fees are $50. So the total is $15,986. Court fees are $130. Service fees are $78.10. Attorney fees are $75. So the total of court fees and attorney fees is $283.10. And the judgment that we are seeking is $16,269.10.
Well, they aren't here. You may submit a default with the writ date was March 30th.
Okay. And they're still occupying the premises, right, Chris?
That is correct.
This goes under the category of no good deed goes unpunished, perhaps, but at some point your management's going to say, we just can't carry this trailer month after month with no rent. All right. All right. Submit a default judgment in the amount of $6,269.10 with a writ date of March 10th.
I mean,
and I will sign
16.
it.
It's 1/6.
16269.10.
Correct.
All right, very good. All right, thank you. That takes care of all the memory lane cases.
Thank you, Your Honor. Thank you, Stuart.
Thank you. Meg, are you here?
Yes, Judge.
Mr. Kloppenstein is here. Would you like to talk to him in the breakout room?
Sure.
Craig, why don't you go in the conference room and I'll hook you up with your lawyer and you can talk to her. I've got a couple of civil matters we're going to address, and you guys can talk in the meantime.
Thanks, Judge.
part that needs to go to the bench and having the ground so that, I mean, I guess.
Well, yeah, got caught back up there, it seems. We're pretty close.
Yeah, we got.
Go ahead and close that door, Craig. Oh, I don't know if you can hear me.
Status conferences in circuit court going on via Zoom here as well.
They need this room?
Yeah.
Well, you got about 5 minutes.
Okay. Otherwise, we can staff it in here for you.
All right.
Judge, it'll be Craig and I will be able to speak if they need it for a criminal matter. That's okay.
Are they there right now?
Paul Gibson's meeting with his people. He's got 2 scheduled for 2 o'clock Zoom for status conference.
All right, we'll be out of there by 2. Now that Judge Stutzman is meeting virtually, we got a lot more demand for this room. And we haven't quite figured out what our room is going to be when we relocate.
Yeah, I was thinking about that. Like there's a little bit of room by the chief defender's office.
We're working on it. All right, everybody can consult. In the meantime, I've got 3 people here on general civil cases. And let's address those. Every day in the middle of our landlord-tenant docket at 1:45, like a clanging broken bell, I have civil matters. And we stopped that to address some other matters. So somebody is here as a telephone number. I'm not sure who that is. I got Michael Stein. Mr. Stein, which case are you here on?
Good morning, Your Honor. I'm here on Ethan Bingaman. It's a motion for summary.
Right, that's Capital One versus Bingaman.
Correct.
Mr. Donnell, which case are you here on? It would be better if you'd unmute your microphone.
So sorry about that, Judge. I got 2 with you this afternoon. One defendant is Alan Gernat, G-E-R. And then the other is Henry Crawford.
All right, you're on the Optalis cases. All
Yes,
right, and Ms. Page, does that mean you're here on Notre Dame Federal Credit Union?
Correct, yes.
All right, well, let's see who is here. Someone's here by telephone only. Somebody's here.
Yeah.
Number, who am I speaking with?
That's probably me, Judge. I'm Colin Potter for the Notre Dame case.
All right. All right. Let's take care of our default first, which is Capital One versus Ethan Bingaman. That would be Attorney Michael Stein. It's afternoon here, at least it feels like it. This is file 252675GC. It's titled Capital One versus Ethan Bingaman. The amount at odds is $8,670. This is the time and date set for a motion for summary disposition. Mr. Bingaman filed a general denial that he printed off the internet and did a pretty good job and got past default, but summary disposition is a higher standard. He's now not here to argue about it. And plaintiff has submitted an order. Mr. Stein, what's your P number?
71421.
All right, you would ask for a default in this case?
That is correct, Your Honor.
All right, 8,838, which includes damages of 8,670, court costs of 168.40 plus interest at 9.99%. So I'll sign that order granting summary disposition. And it failed to appear. C, default order. Many of these 145 hearings are summary disposition. One of my not favorite things to do is try to explain to lay people what a summary disposition hearing is about, but he isn't here. So the order is 8,838.50.
I'm
Your
sorry,
firm
can you
has
say it again?
provided
8,000.
8,838.50.
And the firm provided an order, Your Honor?
Yes, they did.
Great.
So I've signed the order, the default is entered, and you can go on about your business. So thank you.
Thank you very much, Judge. Have a great day.
All right, I'm working on it.
Me too.
All right, Mr. Donnell, I set these for hearing. There are two of them. Neither defendant is here. Optalis Health versus Henry Crawford. File number is 251424GC. Optalis Health versus Alan Gurmat. File number is 252425. The clerk flagged these for me. They had very high attorney fees, higher than the $75 statutory attorney fee in a default case. The plaintiff asked for damages in the amount of $4,083, costs of $312.05, and an attorney fee in each case of $1,650 for a default judgment. The Michigan statute allows for a $75 statutory attorney fee. So I set a hearing regarding the attorney fees. See if you know something I don't.
Judge, in the admissions agreement contract, it's section 4A5 on page 3. Says residence responsibilities, you will, and then A says pay us, and subsection 5 says within 30 days of the date of the bill, if we hire a collection agency or attorney to collect payment on your account, you will pay for those collection costs. So it's a request pursuant to contract.
Well, you're speaking about that as if I have it.
I believe it was attached to the complaint.
Let's take a look. Admissions agreement. Section 4 under residence responsibilities. Within 30 days of the date of the bill, if we hire a collection agency or attorney to collect the payment on your account, you will pay for these collection costs. Well, they aren't here to argue about it, and I'm not sure that supersedes the statute, but the defendant did not appear. section 4A5. Of the admission agreement. Provides for attorney fees. Arguably, if they had counsel, I guess we could argue about it. The quote is, if we hire a collection agency or attorney to collect payment on your account, you will pay for these collection costs. It doesn't say actual collection costs. It just says pay for these costs. So if I set the cost at $75, that's what they would pay. It doesn't necessarily supersede the Michigan statutory attorney fees scheme. But they aren't here to argue about it. I don't have to like it. I don't like a $1,600 attorney fee on a default case. But they aren't here. So I will sign the order. This is in the Henry Crawford case 241424 GC. Default judgment entered this date 3/23/26. Total of $6,045.38. In Optalis versus Alan Gimrat. Well, I think that section is subject to challenge, but I can't be an advocate for the defendants. And they aren't here to argue about it. So again, I will enter default as requested. And the amount of Judge Patterson already signed this. I'll supersede it. It's in the amount of $7,049.89. $7,049.89. All right, I've granted each of your requests. I can't cross the line from judge to advocate. I think it may be subject to challenge. Doesn't say actual cost, it just says you will pay the cost. And the cost under the statute would have been $75. Nonetheless, I scheduled a hearing, nobody appeared, you pled your case and cited this section of the agreement. And so I've entered your default judgments as requested. All right, thank you, I'll see you again.